Hi, I'm Bailey Compton and
I'm Cameron Compton.
and we're both from Leverage Group. Many of you have come across us in the last 12 months and we wanted to wrap up 2019. It's been one of the fastest years we've had. We've had amendments to the Conveyancing Act which deal with off-the-plan properties, apprehended domestic violence orders, new changes to tax laws, and coming in 2020 is the reforms to the Property Stock and Business Agents Act, soon to be called the Property and Stock Act. We thought the best way to wrap up 2019 is to actually talk about 2020 and what it's going to mean to you. The new legislative reforms are going to be the biggest change we've had since 1941 when they started regulating legislation. It's going to change your workplace management or your workforce management, and it's going to alter the compliance mechanisms you need to put in place for running your agency. It's also going to introduce a whole pile of new terms such as assistant agent, licensee in charge, class 1, class 2 licenses. It will change the way you do your corporations and trusts. Cameron and I have spent the last 12 months, Cameron advising you guys on how to get your licenses and me talking about the law. We thought this was a wonderful opportunity to actually talk about what's going to happen, especially since Fair Trading are today sending out to licensees a whole pile of letters explaining to you what the new laws would be. We wanted to try and debunk that and try and put it into a simple set of terms for you. So where should we start, Cameron?
I think the best place to start would be the changes to the corporation licence because it affects a lot of businesses that are running currently.
There's 8,000 corporation licences across New South Wales, and those 8,000 businesses today will receive a letter from the Office of Fair Trading. And many of you who have 2 licensees in charge will get a special letter from the Office of Fair Trading saying that you need to sort out your practice. The new Property and Stock Act will do 2 things to corporations. Firstly, you'll only be allowed to have 1 licensee in charge of the corporation, and 2, you'll be able to have 1 licensee in charge of the corporation, and you'll be able to have many branch offices which won't have to have a licensee in charge. So let's deal with the second one first. In terms of the branch offices, under the current law, every branch officer has to have a licensee in charge. Under the new laws, you'll be able to have 1 person in charge for the whole company, and you'll be able to have anyone in charge of your offices. So you'll be able to have 100 offices across New South Wales with 1 person overseeing them. The only cat's cry is that Section 32 of the Act will still require you to be able to demonstrate proper supervision. And if you're going to have multiple offices, you'll need to make certain your compliance is in such a situation where you'll be able to prove to the Office of Fair Trading that you can oversee what they're doing. And using the words from the case of Davidson versus Commissioner of Fair Trading, you'll have to ensure that you can accurately oversee the execution of the duties of your staff. If you can do that, you'll be okay. The second one says that you can only have 1 licensee in charge of each corporation. And most of you are going, well, how would you have 2? And if you're running a multifunctional business, real estate and strata, for example, many organisations have a licensee in charge of real estate and another licensee in charge of their strata management business. From next year, you'll only be allowed to have 1 licensee. So one of your licensees will have to go and get both licenses, or you'll have to change your structure so you'll have a real estate agency corporation and a strata management corporation, and that way you'll have 2 separate licensees in charge. It's going to be more complex, but that's the way the legislation will be important about it. An important date for your diary, however, is 1st of March next year. If you have not advised the Office of Fair Trading by the 1st of March 2020 who the licensee in charge of your corporation is, you will not be able to operate a trust account after that date. So those of you who have 2 licensees in charge, make certain you put in your diary that you need to do a written letter to the Office of Fair Trading clearly outlining who your licensee in charge is so you can continue to operate.
Now, Ben, do you want to tell everyone what will happen to the other partners or other licensees in charge of the business?
Great question, Cam. Because a lot of people have set their businesses up, and they're essentially partners operating under corporations, where you might have 4 directors who've set a business up. They've all set it up jointly, and one of you have chosen to be the licensee in charge. Under the new laws, you'll be able to maintain your licence and be a Class 1 licensee if you have been in charge of that, have held your licence for more than 2 years. Let's go back a little step. They're going to put some transitional clauses in for licensee in charge. Many of you would have been directors of corporations and held a licence for more than 2 years. If you want to become a Class 1 licensee, all you need to do before 23rd of March next year is make an application to the Office of Fair Trading and you'll be granted a licensee in charge. There'll be two categories, or two transitional points for people to be appointed as Class 1 licenses. Number one, those who held a licence for 2 years, which we've just covered. The second category will be if you hold a licensee in charge, so if you are the licensee in charge of an organisation at the 23rd of March next year, and you will be granted automatically a licensee in charge. So provided you have a business operating by the 22nd of March next year, and then operating the business I'll come back to in a second, you will automatically be given an LIC Class 1 after the 23rd. The one thing I should say to you is what does it mean by operating a licence? Abundantly clear would be if you have a corporation which has a corporation licence, which you are licensee in charge of that corporation. Alternatively, you can have a licence, set up an ABN and register yourself with the Office of Fair Trading as a sole trader. Provided that is in place, your licence and your business ABN by the 22nd of March, you'll be able to apply for the Class 1 licensee in charge.
What about all the Class 2 transitions? So anyone that is currently sitting on a full real estate licence in the current regime, what will happen to them when they change over?
Those who have a licence under the transitional clauses will be automatically granted a licence. It's a simple process that the Class 2 licence agent, if you're a licence agent now, you'll be automatically be given a Class 2 licence.
Is there any benefits to or disadvantages to coming in under a Class 2 licence as opposed to going for a Class 1?
The only disadvantage of coming in under Class 2 is if you are going to conduct your own business, you won't be able to conduct your own business. For example, you won't be able to be an independent contractor. Let's have a look at project marketers, for example, Cameron. The project marketers operate on a commission-only basis. Under the current rules set down by the Fair Work Commission, you cannot be an independent contractor or a commission-only person unless you are totally an independent contractor. And the only way you can be an independent contractor under these new laws is you must be a licensee in charge. So if you want to operate independently, you want to work in a project marketing business, you want to be a mortgage broker who wants to be a licensee in charge or run their own business, you need to be in a position to be a licensee in charge Class 1 before the advent of the new regulations.
So what I understand from this is if I have the opportunity to, which is now, I should go for a Class 1 licence if I'm an agent.
You should always take opportunities when you're doing business to get the best opportunity possible. I always use the example that if you want to run your own business, if you don't start by the 23rd of March, it will take you 3 years to be able to conduct your own business. I know as a solicitor that if I wanted somebody to take over from me, they'd need to train for 6 years before they got it. It's very hard to run a business if you don't have succession plans in place from day one, and the only way I can see it is everyone should take the opportunity to be in a position to be Class 1 by the 23rd of March.
Okay. Now at the moment we've currently got 20,000 certificate of registration holders in New South Wales. What's going to happen to them and what would you advise them to do in the preceding months?
This is the real change. The Office of Fair Trading have been portraying that the licensee in charge category is the change to the legislation. Now there's 3 levels. You got your assistant agent down here, which is you'll get a certificate as an assistant agent under the new legislation when you enter the marketplace. Those people have to do a small certificate of registration course, but they will be given 4 years to go to Class 4 licence. It's totally an apprenticeship. And those people will take 12 months. They have to be in the industry for 12 months, keep a logbook before they move to the Class 2 licensee.
In addition
in addition to getting their Cert 4. And to go from the Class 2 to Class 1, you're going to have to do 2 years as a licensee in charge, licensee, keep a logbook, and do a diploma of property services agency management. Those people who are certificate of registration on the 23rd of March will be made an assistant agent.
So that will be effectively downgraded from their role.
Fair Trading would like to think that there's not a downgrade, but what they've actually done under the legislation is this person who holds a certificate of registration now, who carries on the functions of a certificate holder, let's go back a bit. Under the legislation now, it's the person who holds a certificate of registration carrying on all the functions of a real estate agent, except for running a business and running a trust account, which is what the licensee in charge will be limited to. So to do those things, you'll need to be a licensed agent. The assistant agent will be able to assist a licensee to carry those functions. It's been clearly accepted that an assistant agent can't sign an agency agreement, and because they can't sign an agency agreement, they won't be able to do an inspection report on an agency agreement. They won't be able to exchange contracts. They won't be able to do certain things in property management. Strata managers won't be able to attend annual general meetings, issue budgets, do financial reports, unless you have a licensee signing off and doing everything for you. So that assistant agent's position will be exactly what it is. It'll be great for the receptionist. It'll be fantastic for your bookkeeper. It'll be fantastic for the people who are acting as PAs to the salespeople, or assistant property managers or assistant strata managers. It won't be any good if you're out there being expected to operate independently. Strata manager, property manager, sales executive, all those things you won't be able to do without having a licensee in charge. Most of all, a lot of people are saying that, oh, it's just the regulations. The big concern for leverage, which we've portrayed this year, is it's not just the licensing problems. If you have the wrong category of licence and it goes wrong, you run two risks. A, you could be sued for professional negligence, and B, if you are sued for professional negligence, because you have your own licence, your professional indemnity insurance may be refused. So it's so important that you get all these licenses, these ducks in a row where you sit. And if you're an experienced person having a COR now, certificate of registration now, you should get yourself into a position of at least having a Class 2 licence, or your life will be curtailed.
Now, I did hear a rumour out there that if you do become an assistant agent, you'll no longer be able to hold yourself out as an agent when you go and see customers, or on your business card or anything like
Your
that.
business card will have to carry the term assistant agent, and you'll have to tell everyone assistant. Could you imagine trotting into an expensive house and saying to a person who's been selling for many years, I'm an experienced agent, and handing over a card that says, assistant agent. Who's going to sign up with you?
No, I wouldn't be asking for the Class 1.
That's right.
Yeah. Now, there are new CPD obligations that are going to arise for each different class. Do you want to take us through them, starting from probably assistant through to Class 1?
I think it's a great idea, but let's start down at the assistant agent level. You'll have no CPD.
None.
No, but you'll be expected to get through your certificate 4 in property services real estate, or your certificate 4 in strata management prior to 4 years passing. If you don't do it in 4 years, you're suspended from the industry for 12 months.
Okay, so they're actually going to revoke assistant agent certificates if they do not complete their Cert 4.
No, that's exactly right. If you don't get through in 4 years, you're out of it. So what the whole concept is that you at least do a quarter of your certificate 4 in property services every year, leading through to it. Now, CPD is broken up into lots of three, and for a licensed agent, they'll be required to do 6 points. For a licensed, let's go back a bit. For a licensed agent, they'll be required to do 6 hours. Gone is the concept of points. We are now replaced by the concept of hours. So a licensed agent, Class 2, they'll be required to do 6 hours. For a licensee in charge, they'll be required to do 9 hours. Now, the way they've broken it up, Fair Trading, is you'll have 3 compulsory points, which everyone has to do, 3 elective points, which both the licensee in charge and the licensed agent can do, and there's 3 special business points for those who are running licensees running their own business. The great thing about that is that those who are running their own business will get training for business purposes, not just the same stuff that the person down the bottom will get. Now these 9 points hours can be done at the same time or different times. But unlike the old legislation where you had to do it before the date came up for your licence renewal, there will be a CPD period running from the 24th of March to the 23rd of March each year, and that's going to be the same category of your licences. And licences, you can get a 1 and 5 year licence now, but you're going to still be required to the 6 and 9 points. Now Kevin, you and I are now working on how we're going to do those 6 and 9 points, and we're looking at some really entertaining and provocative ways to run that, aren't we?
Yeah, so we're looking at doing seminars or full day, courses so people can get their 6 and 9 points, 6 and 9 hours done all in one go. So it'll be a lot more interesting than the usual 2-hour CPD in the morning or afternoon.
Look, it's meant to make a difference. Fair Trading are very strong on higher education, but we don't want to just do education. We're talking heads. We're looking at education which adds to your ability to sell, do property management, do strata, or more importantly, profit your business.
Yes. Now, one thing that has also arisen that not a lot of agents are across because they're all worried about their licensing, but I believe Fair Trading has gained some newfound powers.
There are compliance issues, and they've brought in some new laws which require you to maintain your trust and to make one person within the organisation. It's going right back to our beginning. Each corporation will have one licensee. That licensee in charge will be responsible for the trust. But they've also been given some extra powers under Section 196 of the Act, which allows Fair Trading to come into your office, issue you with a show cause and suspend you indefinitely while they undertake an investigation. Unfortunately, 196 comes with no appeal power. In a case called Market Turner versus Commissioner of Fair Trading in 2007, any appeals on these suspensions are not available. So Fair Trading will now be able to walk into an office. If they find it not compliant, they can issue you a notice and put you in a position of not being able to fund your defence for a period of however long they want. It's a very strong power, and I think what we now need to look at as an industry is ensuring that we've got benchmark compliance so that doesn't happen to your company.
Okay. Now, with all these changes, obviously there's going to be effects on the industry. Do you kind of have any forecasts of how you think things will change, or things that people haven't already thought about?
The way people will have to deal with it is you'll have to look at your workforce management a lot more carefully in terms of how you recruit people, who you recruit. Most importantly, you need to get your ducks in a row before the 23rd of March. The big change, apart from your whole recruitment strategy starting, because you won't be able to go and get a highly experienced person and get them to a licence, you need to put it into an assistant management strategy. So you'll end up with a hierarchical structure in your office of licensee in charge up top, who'll be with a number of licensees reporting to them, and under that assistant agents will be reporting to the licensees. So it's very much a public service corporation structure. A lot of small businesses won't be able to do that. I think what's really important for the small businesses, they have a succession plan of a second licensee in charge. If it's a husband and wife team, both of them should have licences. If they're business partners and one has a certificate and a licence, the certificate holders should get ahead and get themselves a licence. The big changes will be that in the project marketing area, we'll be looking at more and more situations where we'll need to get independent contractors in place. That's going to be an emerging part of the new network. We may also find that licensees will move to another state to actually allow for more flexibility in their programs than operating from within New South Wales. It's going to be a lot of change. The big change for me, however, is you're going to have to get your compliance structures right. Good policy manuals, good mechanisms to ensure those policy manuals are followed, good oversight, really good human resources management, and on top of that, people who can assist you to do compliance. And I think that's the place where Leverage really wants to get involved under the new legislation, helping organisations, allowing organisations to sell, but making certain their compliance is sealed up protectively.
Now, the last question I have is, I believe not a lot of people know about this, but there are going to be new restricted categories for some industries that kind of didn't fall under the blanket fix that they put over everything shelves?
Well, when they took away the business agent's licence, the on-site property manager's licence, and the buyer's agent's licence, they realised there's a whole category of people's businesses that, if it was all thrown into this new legislation, wouldn't operate. So we've now got a restricted real estate agent's licence restricting you to business, restricted real estate agents restricting you on-site property management, and a restricted real estate agent's licence restricting you to buyer's agents. The beauty of that, however, is it's going to lower the experience. So if you undertake the diploma, you won't have the experience time requirements for on-site property management which you have with all the other categories. So if you want to go into a straight real estate agent's licence, you'll have to do your 1 year as an assistant agent, 2 years of licensing in charge. But if you're in the on-site property management business, and on-site property management where you operate property management from one building, you look after that building, you own a place within that building. There's a lot of protections already in place. Fair Trading said, look, they don't need to do 3 years. As long as you do your education, you won't need your experience requirements, you won't need to keep your logbook. I've got to say, from a leverage perspective, we had a lot to do with that. And I think it's a good move for the government. It really, in many ways, it preserves businesses which already were functioning successfully. And by the way, anyone who's questioning those restrictions, there's never been a complaint or a prosecution of a buyer's agent or on-site property management anywhere in Australia. It's a good move.
Interesting news. What about bloodstock only agents, which a lot of bloodstock agents will find great relief in this?
Well, it's only your bloodstock agents, they're going to allow bloodstock agents, so it's not going to affect those who run the business. If you're running the business, you're still going to have to be a licensee in charge. However, if you're just in the cattle yards and you're working for somebody, you will be able to get an assistant agent's certificate restricting you only to selling bloodstock. It's great for those in the country, good in regional areas, but it really is a restricted thing for those who are just doing bloodstock. But from what I understand, there's a lot of people out there who just sell cattle and sheep and goats and alpacas and all those other things, and don't ever look at a property and don't want to run their own business. So this is a fair way of managing a group of people who don't fit, well, it's like trying to get a round peg into a square hole, and it fits perfectly for those people in the country.
Yeah, awesome. Well, I think that's all the questions I have. Is there anything else you want to kind of add?
The only thing I'll add to the industry is we're going into 2020 and we should have 2020 vision about the industry we're involved with. Get your licensing in charge in place. Make certain you get yourself a licence before it's too hard to get one. And make certain you start sitting down talking to people about how you deal with your workforce management and your compliance. In 2020, when we get back, Cameron and I will look at doing some videos outlining these things in more detail. Today was just a coverage of something simple and easier for people to oversee. We'll start talking next year about your ramifications, the things you have to do in your business. And for those who've come through 2019 with all the changes, what I've found over the years, this is not the first reform I've lived through. I've lived through the 2003 reforms, the 1993 reforms, etc. The funny thing is, we might think that Armageddon is upon us, but this industry also always survives. Leverage hopes to be there and provide with the products, which allows people not only survive, but make a success out of the industry. For those who are out there, Cameron, we wish them all a Merry Christmas and a prosperous 2020.